Hello, everyone. I'm John Hooks, and I'm here with the Education Law team of Adams and Reese. I've got Elizabeth Maron here, Jim Keith, and KaShonda Day, and we're here with our fourth update on the coronavirus guidance for school district administrators. This has been recorded on March 23rd, 2020 at approximately 3 o'clock Central Standard Time. We're going to take up a special education update today, as well as look at some employment issues and some questions that you all have had about copyright issues, donating cleaning supplies, and holding board meetings, so a miscellaneous group of topics at the end. We're going to try to keep this recording to about 20 minutes so you can speed through it and take up those topics that are most meaningful to you. Up first on deck is KaShonda Day, who's got a special education update for you.
Yes, John. On Saturday, March 21st, the United States Department of Education issued a supplemental guidance fact sheet on providing special education and related services to students with disabilities while schools are closed due to the COVID-19 outbreak. In the supplemental guidance, the DOE reminds school districts that they should not opt to close or decline to provide services to students to address issues related to students with disabilities. The guidance is clear that complying with the IDEA and Section 504 should not prevent schools from providing educational opportunities to its students through distance learning. It was also clear that a FAPE, in fact, can be provided to students with disabilities through distance learning by way of virtual, online, or telephonic means. The guidance also provided some suggestions, which include distance instruction, teletherapy, teleintervention, meetings held on digital platforms, online options for data tracking, instructional packets, projects, as well as written assignments. In essence, the supplemental guidance does anticipate and expect that schools will provide services to its students with disabilities as long as the school districts are providing services to its general ed students. And in doing so, as we previously said, you have to look at each student's IEP and make a determination as to whether any services can be provided during this time. And if so, an amendment to the IEP is necessary. What schools need to do is to contact the student's parent and discuss the proposed amendment. If the parent agrees to the amendment without an IEP meeting, you have to make sure that you obtain that agreement in writing. You can use either the IEP amendment form or amend the IEP itself. If you choose to use the amendment form, be very specific about what the change is, what services will be provided during the school closure, what services won't be provided, and the duration of the services. Parents must also receive a copy of the amendment and a prior written notice. Additionally, all members of the IEP must receive a copy of the amendment form. If services cannot be provided during this time, or if the full IEP cannot be implemented, when schools reopen, the IEP teams will be tasked with making an individualized determination on whether and to what extent compensatory services are warranted. Now, the last page of the supplemental guidance is related to IDEA timelines. And in summary, the supplemental guidance does not provide any specific relief on timelines under the IDEA. Instead, it says that parents and school districts are encouraged to work together to meet IDEA timelines.
Thanks, KaShonda. Obviously, lots of moving pieces on the special education front, and even tomorrow, the Council of School Attorneys is going to host a call about special education services. KaShonda and Jim, or the team, are monitoring all of those updates, and so on Wednesday, we hope to record update number 5 for you that should be available either Wednesday afternoon or Thursday morning, and it'll include a summary of some specific suggestions and further discussion that attorneys around the nation have been having about the provision of special education services. We've also been taking a look at a couple of employment issues that you all have been questioning us about. One has to do with garnishments, and Elizabeth Maron has been taking a look at those issues. Elizabeth?
Yes, and this specifically has to do with Executive Order number 1462, which was also signed on March 21st, so that was on Saturday, There's been a bit of confusion about this order. This order was basically directed to the Mississippi Department of Employment Security. In the executive order, there's a reference to suspending different types of collection efforts, and those efforts relate to what MDES does to collect the charges to employers and to collect overpayment of benefits. Those collection efforts are not the actual garnishments that are in place already for school district employees. So that regular process of properly entered garnishments, the schools are to continue collecting those garnishments. This executive order has nothing to do with that. So to the extent there's been any misunderstanding about that, please know that you're to continue forward with your usual process with regard to garnishments.
And Jim Keith is alive and well and has been looking at employees on FMLA leave. Jim?
Yeah, John, I think it was clear that the governor intends for all school employees to be compensated regardless of what kind of leave they may or may not be on at this time. And since it's left up to the local school boards if they want to make any particular distinctions, theoretically and legally, school boards could make some exceptions, but I do believe that it was the governor's intent to pay everyone who may already be out on some type of leave, particularly FMLA, and that they too would be paid from the administrative leave provision of that statute. So I think at this point in time it's clear that we would be paying those employees as well.
What about part-time employees, Jim? We seem to keep getting a lot of questions about part-time employment under this act.
Yes, I've got a lot of calls about that, and I think each district has got to determine who constitutes the part-time employee workforce. And what I think the intent is to identify those regular part-time employees, those employees who have a record of working for you over the last several weeks. It may be a minimal number of hours one week, some more the next week, some more the next, or maybe even skip a week or two, but these are regular part-time employees, and then you would calculate an average over a period of time, such as over 2 weeks or a month, to figure out what you would be paying them during that interim. There are some part-time employees who may come in and do after-school daycare, things of that nature, which obviously are suspended, and I'm not sure that those programs would constitute or fall in that same category. But again, that is for each school district to look at and determine who is going to make up of that category. One example that came up was someone who had worked a couple of hours in January and have not worked since. Would you consider them part-time? And I would not consider them to be a part-time employee.
Also, we've gotten in our Brave New World a lot of questions about copyright issues using social media, Facebook, Zoom, FaceTime, and so on. Jim, what can you tell us about what you've been learning about these issues?
Yes, we have some copyright folks in our law firm who have looked at this issue, and you have to be very careful if you're in a situation where a classroom teacher records a presentation and then puts it out on social media at a later time or puts it out on YouTube, and that's where the copyright violations come in. I think you have to look at it and ask the question, what would you be doing with this information if it were being presented in the classroom environment on a real-time basis? So if that's allowable in a classroom and the platform that you're using is real-time, then there should be no copyright violations that are incurred. So it's only when you record it and then present it at a later time would you have to be concerned with some potential copyright violations. The same thing goes with copying materials. If you could not copy those materials in the classroom environment because they are copyrighted and we have not paid for the extra copies, you could not do that in this situation and send it home to the students. Again, just assume that what you're doing is what you would be doing in a classroom, and as long as you conduct it the same way you would do in a classroom, I think you would be okay.
A lot of questions coming in, too, about donating cleaning supplies, face masks, gloves, et cetera, that you all might have at schools, to hospitals, and places where our first responders are working. Jim, have you had a chance to look into this issue today?
I have, and I've even talked to the Office of State Auditor, and they gave me an opinion today, not an official opinion, but it was a discussion, and they did say that there is no authority to grant or to give any kind of supplies of any nature to a private hospital. If you want to donate supplies to a public hospital, there's a specific provision in the statute that would enable you to donate supplies to the governing authority. The hospital itself probably is not the governing authority. It's probably the Board of Supervisors or some county governmental entity. And if you run into that situation, we'll be happy to help you go through that process. But you cannot donate these supplies to a private entity.
And finally, the last issue on our agenda today has to do with holding board meetings. I know there's been a lot of discussion with various aspects of technology. Some of you are contemplating getting very experimental with Zoom and so forth. Jim, any thoughts about that, or team, any thoughts?
We've had numerous calls on this issue. Keep in mind your board meetings are public meetings, and whatever platform you use, you have to ask yourself the question, will the public be able to sit and view or to listen in on those meetings? The public does not have a right to participate, so you do not have to give them access in that way. So, for example, you could have the board call in on a conference call, and a speakerphone be placed in the boardroom where the board members would normally sit, and the public could come in, obviously observing social distancing and all of the rules that CDC has put out, and listen to that conversation. If you use a platform like Zoom or one of the others, you would need to make sure that your technology folks have the opportunity to mute the calls or the connections of those people who are connected from the public, because obviously they do not have a right to participate in the meeting. They can only observe it. I do know that some school districts have gone to streaming their board meetings, so if you do have a board meeting, you could stream it live and put it on your school district website, and that would give the public access as well. So just get creative in this arena. There has been a question as to whether you can limit the number of people who come into a board meeting if one takes place on school premises. And I think obviously we would have to continue to follow the CDC and State Department of Health orders with regard to no more than 10 people and the 6-foot distances and so on. So it may very well be limited as to how many people could come in. So just get creative and figure out ways that the public can observe so that your board can still conduct their meetings.
And that's a quick update from the education law team at Adams and Reese. This is our 4th update. Be on the lookout for our 5th update that should be coming out on Wednesday or Thursday morning. A quick message from our lawyers advising us, however, this is not legal advice that we're giving you. Ironically, the fact-specific nature of a lot of these questions that you all have asked is incredibly intense, particularly with your employment questions having to do with FMLA leave and payment of part-time employees and other things that we've discussed on the call. So please reach out to one of us with your very fact-specific question, and we'll be happy to look further into the matters. These are considered general, broad overviews of where we are, and more than anything, to give you some inspiration or thought so that you can recognize the issues that confront your school district at this time. Thank you for joining us, and we look forward to our 5th update that's coming out on Wednesday or Thursday. Thank you.